Good afternoon, dear participants. I just wanted to add and emphasize this point and the discussion even of this document. That's a breakthrough, really. And what else? But still, that's the first document, and the status of kind of this document have to be approved and have to be applied as fast as possible. In case we will make it norm document approved by the Ministry of Justice, it will take another year for us because lots of issues may arise. And in some cases we are like pioneers, we are opening the way. And it's hard to adopt such decisions, and we can make mistakes. And as Oleksandr Ivanovich have drafted this document, and they started with the temporary regs or bylaws, and when we managed to learn lessons, we managed to make it a law. And we had a dream, actually, that we are going to have procedure code and to specify everything. Just wanted to do it stage by stage.
The question of registering, not registering this document at the Ministry of Justice has some positive advantages and as well as risks. Well, we should discuss that. As for the document itself, undoubtedly, no matter what document is, no matter how long discussion is, at some stage the Anti-Monopoly Committee should just finish this work, put and put it into effect. Nevertheless, I would like, just in view that we have in the audience, we have represented not only from this government and from the civil society as well as from the business circles. Though for those who would be really paying these fines if something is not complied with, in this point of view, I would like that under any circumstances to not have the formalism in a document. That is, the document in itself is built by 95% just relating to the practical subject matter. For example, as for the issue whether we need to replace the principle of proportionality and the substantiation non-discriminatory nature, the more detail the better. Let's keep both things. So let's have the principle of the law to be branched into two. For this detailization to be present, for us it's important because whether it will be registered at the Ministry of Justice or not, it's an important document for courts. If something is infringed, then it can be argumented and will be a prompt while submitting actions. Nevertheless, some gaps are still present. The question is about the economic concentration. We mean the concentration as the medieval seriousness. On the one hand, its economic concentration might lead to the total monopolization in the market. It's the same way as cartels, but yet at a long-term basis. If we want to range infringements by their types, then in that regard, we are just confronting the formalism. With each type of infringement, there will be a threat of monopolization. Aside from the unfair competition, the not submission of the information. Therefore, in this regard, one should. I'm not ready now. I think that in close future we'll have a meeting of the public council. Then we'll have this discussed in detail. Probably these main criteria should be just unlawful advantage and the damage caused. by the infringement, because to arrange it by a type of an infringement, that's already a deviation from key principle. Why I was just concerned by them, if the committee just imposed earlier just in the size of 300,000, but under this methodology it will be just more in millions, but that didn't cause damage to concentration. I might be mistaken, but it seemed to me that not. Therefore, in such volumes for infringement that didn't cause any damage to competition, probably it's wrongful in present conditions, particularly when the economy is in the crisis, and particularly when some cases of concentration are quite complicated for measuring, and with regards what we need to get in the permissions. When just what at the third, fourth levels, when third parties are involved, not always with the involvement of the persons responsible. Therefore, this aspect is very important. That concentration, that particular attention should be paid to concentration, by imposing the highest fines for infringements that led to monopolization, but not to those infringements that have not made an impact on the concentration. In another aspect, item 6. Well, out of this the proposals were submitted. Indeed, I would like to corroborate that article. Well, part 4 of Article 52, to which Oleksandr Zavada referred, it is, well, the time just passed, and I am already just feeling despair, because without an activity, a person might be brought to responsibility. That is, I feel in this a principle of violation of the law rule, where a person should be responsible for his or her activities. If we will extract it and will make only a reference to that article, then we violate the principle of certainty, which we would like to attain. In this situation, I vice versa consider that this probably not quite well worded paragraph 4 should be explained, probably not now, probably in next explanations, but one should understand how the committee would treat it. Probably the individual didn't know about, and know, just conventionally speak, an abstract example, for example, a pawn shop has been bought, or just a pawn shop has acquired a stolen thing, whether it bears the responsibility if it earned some money, but if it's an accomplice in a crime, and so on and so forth. For the cleanness of a theory, for at present not to have problems and concerns from the business circles, if the committee declares that it will apply this provision while just proving just inactivity or activity, that the individual didn't prevent commitment of the crime, probably it will be perceived properly. But it's just an arguable article. It's not the final proposal. It's still the answer how to apply this paragraph would be a good thing. Of course, on rights. There's a person that had rights. It should be extracted. In the paragraph itself, it is mentioned at the beginning, but where just there is a list of individuals to be fined, it is not mentioned. Only about those who committed some offences and obtained advantages, but about those who were entitled, that fines are not to be imposed in any case. Another question has been an interesting topic on compliance, whether it mitigating circumstance or not. I would like to draw the attention that the compliance is included into not linear things. If infringement is not evident, what has been criticized because of the presence of the compliance. This mitigating circumstance probably not manifested too much care. But if the the presence of the compliance, the compliance only just confirms this, maybe just aggravating. I wouldn't be too quick to include it into mitigating circumstances. It should be assessed dependent on the situation. As for, in principle, probably that's all. I only just sorry that I was not able to much a chance to present it in a more detailed picture, but yes, I would like to support the ideas in this regard, as well as to provide support to the open discussion of this document. Thank you.